ILO Conventions on Migrant Workers' Flexibility, Validity, Relevance and Scope. The ILO estimates that worldwide over 164 million migrant workers, almost half of them women, are moving from one country to another in search of employment and better wages. This labour migration, if well managed, can have positive development impacts benefiting migrant workers, their families and their countries of origin and destination. Yet the current labour migration governance system is not able to meet modern international migration challenges. This can result in large protection gaps in terms of wages, working hours, occupational safety and health conditions. Higher risks also exist that migrant workers are being exploited due to poor labour and skills matching. The ILO has adopted 2 international labour conventions on migrant workers that provide a protection framework for overcoming these challenges and ensuring that labour migration governance is fair and effective. Both these conventions bring benefits to migrant workers and the private employers or businesses that employ them. Unfortunately, only 49 countries have ratified Convention number 97. Convention number 143 has been ratified by merely 23 countries. Unless ratified, the conventions would not have to be implemented by governments, leaving many migrant workers unprotected. Many countries care about protecting migrants, so why haven't more countries ratified them? One reason may be that many countries harbour misconceptions about the requirements and principles of the conventions. Some have doubts about the extent to which these international standards address modern national and global labour migration challenges. Their flexibility, validity, relevance and scope in responding to today's labour migration governance challenges is still not widely grasped. Countries have the flexibility to ratify the conventions either in whole or in part. The principles of the conventions are still entirely valid today and respond to many existing challenges in the governance of labour migration. These include the need to recognise labour market needs, to address labour shortages, and to combat discrimination against migrant workers and promote their equality of treatment with nationals. The purpose of the instruments is as relevant today as when they were adopted. Given the existing concerns about migration among many countries, it is even more pressing that governments ratify them, especially if they want to increase economic, social and cultural benefits of migration. For example, their provisions protect migrant workers against wage cuts in times of economic downturn and migration reforms that may not be in their interest. The ILO instruments also help ensure economic productivity that benefits all. Though some specific categories of migrant workers are excluded, the scope of the conventions is broad. It covers all persons who have migrated or will migrate for reasons of employment. The family of the migrant, including their spouse, children and parents, is also protected. The conventions apply to all sectors of employment, to permanent, temporary and seasonal migrant workers alike, as well as to refugees and displaced persons who are employed outside of their countries. Some common misconceptions about the conventions have made governments reluctant to ratify them. For instance, some governments are under the false impression that both instruments apply only to migrant workers in a regular situation. This is indeed the case for Convention number 97. However, Part 1 of Convention number 143, which deals with migration in abusive conditions, aims to ensure a basic level of protection, including fundamental rights at work, to all migrant workers, regardless of their migratory status. The conventions do not prevent states from deciding which migration policy they wish to apply. Instead, the flexibility of the instruments allow governments to ratify only certain provisions and to ensure that the measures adopted to implement them take account of national circumstances. States may also be under the impression that only countries of destination are obliged to respect the provisions, but the conventions apply to origin, transit, and destination countries alike. Some governments mistakenly believe that Convention number 143 obliges them to grant all migrants in an irregular situation access to social security. Yet, the Convention only requires that among migrant workers in an irregular situation, only those who have contributed to social security should enjoy the rights and benefits acquired from past employment. Some governments believe that Convention number 143 obliges them to extend the residency of temporary migrant workers beyond the actual period of their employment contract. Rather, the Convention exclusively refers to migrant workers who lose their employment prematurely. Those workers must not be considered as in an irregular situation. They should, for the remaining period of their contract, be given the possibility to take training and find alternative employment on equal footing with nationals. The ILO stands ready to assist countries in overcoming these misunderstandings and adopting a rights-based approach to labour migration. In the discussions of the new Global Compact for safe, orderly and regular migration, stakeholders have called for linking these issues to commitments in the UN's 2030 Agenda for Sustainable. Such an approach is paramount to attain sustainable development and ensure prosperity for all.